Greetings.
Welcome everybody, welcome. Today we're going to talk about a couple of things. One thing I'm gonna focus on is magistrate jurisdiction, consent of magistrate jurisdiction under 28 U.S.C. 636 section C5. So we're gonna talk about that. We also going to talk more about the Rule 73 of the civil procedure. We're going to talk about Rule 73 and how that also relates to 28 U.S.C. 636 section C5. Okay, we're also going to talk about 26F reports and things like that, and we're going to talk about a little bit of aspects that are updated on the case. So getting right into it, we want to say all constitutional rights invoked and waived. As usual, thank you for your time, for taking the time out to view this. It's a lot of important information in these videos. A lot of information can be used. A lot of this information you can research and you can validate it and verify this information that it's actually accurate. Okay, getting right into it. Do you have anything to say?
Just welcome to the channel. Welcome to new subscribers. I know it's been a while. We're busy doing a lot of stuff, but yeah, let's get right into it.
Okay, getting right into it. Many of you know that we have a pending federal case in the Ohio Southern District Court in Ohio, in Columbus, Ohio. And in that case, we have RICO charges, many numerous predicate acts that were that were put in the record. Excuse me. We have many different charges against these individuals. These individuals caused monetary damages, and they caused calculatable monetary damages, and they also caused intended damages, and we intend to collect the damage, the intended damage, mental anguish, and punitive damage. We intend to collect all those damages and any other damages that the court deems necessary in this matter. Okay, moving right into it further, I also want to speak about this 26F report. There was a 26F report that the court required to be submitted onto the record. That 26F report was submitted onto the record November 8, 2019. Okay, and in that 26F report, we clearly outlined that none of the parties agreed to the 28 U.S.C. 636 section C5 jurisdiction for consent for magistrate jurisdiction that will be consistent with Federal Rule of Civil Procedure 73. So we found that to be kind of strange. So moving forward, it is our desire to not move forward past March 17th with a magistrate judge. There is nothing in the record to reflect that we have given consent under the 28 U.S.C. section 636 that would be consistent with Rule 73. All right. So that was mainly one thing that I want to address. So we will be addressing that with the clerk of courts soon. And as you all also know that discovery in the case was stayed, and as we stated in an earlier video, that we didn't have any kind of apprehension about the stay of the discovery initially because there was a time frame on it. The discovery was initially stayed for 60 calendar days, so we appreciated that they put a time frame on it. Now I believe it was January 16th, or it was, I think, January 16th or something like that. There was the court took an inquiry and had a telephone status, and it looks like they stay discovery again. So they initiated the stay of discovery for 60 additional days, which is going to go to, I believe, March 16th or March 17th. I believe it's March 17th. And then there's a telephone status conference here on March 17th that we all must attend. But we intend to move forward in this case without a magistrate judge. Okay, we want a constitutional judge, just as we had in Arizona with Judge Diane J. Humatewa. Okay, there was no magistrate on that case because we gave no consent. All right, so the record doesn't reflect any consent. So yes, we will be moving to remove Magistrate Jolson off of the case, just so we can exercise our full constitutional authority. All right. Something else I wanted to touch on. Yes, and just speaking generally about the case, I'm going to say a couple things generally. I know a lot of time has gone by since this whole matter happened. Like we said, this financial scheme goes all the way back to April 20th of 2016. All right, so that's how long this debacle has been going on. Now, I find it very frustrating and I find it very unfair that we have come this far and still we have found no adequate justice in the courts for the damages that was done. We filed a civil case in the the common pleas court in Columbus. That case was thrown out. Okay, that case was thrown out. Though that case had solid, sound claims, it was thrown out.
Exhibits and everything.
Exhibits. It had supporting, corroborating exhibits, affidavits, you name it, it had it. Okay, that was a very rock solid, sound case. What they did in that case was diabolical. All right. What's his name? Michael J. Holbrook. He ought to be ashamed of himself. He ought to be ashamed of himself. Okay. Also, I wanted to speak about our feelings about certain things. We are pissed the hell off about this whole thing that happened, and the time that was lost, of course, can't be recovered, but we want justice in the courts. We want justice in the courts. We understand these torts. We understand these causes of actions that was offended. We understand how this stuff works, and we need our justice. And another thing I want to say on a side note, I'm very, very, very adamant about this because there was a situation that I could remember where I was in the 6th grade and I went to a school called Jennings Middle School in Akron, Ohio. And I actually got suspended from that school in 6th grade because I would not put my hand on my heart and sing the Pledge of Allegiance and say, with liberty and justice for all. And so the teacher said, well, why won't you say that? The teacher was a black teacher, and her name was Miss Powell. And she asked me, she said, well, why won't you say this? I said, because I didn't believe it. I didn't believe it. So she said, well, you have to start saying it. I said, no, I won't. So, I got in-school suspension for that because they regarded that as insubordination because I wasn't saying that. So now, here we are in this situation, and, proofs is all in the pudding. So that pisses me off all the way down to my bone marrow. And there's no words that can describe the passion of anger that creates when you know that people are playing games and not doing what they're supposed to do and acting like they don't know how to adequately do their jobs. I didn't have any law experience before this situation, any experience in any of this, and this stuff had to be quickly learned because these people were out of order. They're caught up in culture. They're doing things the way they do it, and there's a lot of people suffering because there's shortcuts and culture being taken. Okay. There was a video on the mainstream media the other day, not to get off subject, but there was a video where a police officer was caught on the side of the highway, and he was drunk. He was intoxicated while on duty in his car. All right, and the district attorney of that situation was pretty pissed off because he said had it had been anybody else other than that uniformed officer in that car that was drunk, the situation would have went a whole nother way. And the reason why the situation went the way it went, which the officer didn't get any charges or nothing happened to him, is simply because that's culture. That's culture. If you are the general manager at McDonald's and your mother comes in there and she trashes the place, you're not going to put her in jail. Culture. She's cultured in. So that's what I'm saying. We all feel the ramifications from these cultural movements when people adopt things according to culture and create these customs. And that's why you have Monell claims. But yeah, we're not 5 minutes off. We're not 3 minutes off the defendant's asses. In this case, Christmas didn't make it go away. New Year's didn't make it go away, and Valentine's damn show ain't gonna make it go away. We want our justice, and we don't want it now, but we want it right now. We ain't playing with y'all. We on y'all ass. Just like we said, we guaranteed y'all, and we're making right on that guarantee. So, we want our day in court. We want our trial. The defendants have communicated to the court that they would like for us to turn in a reflected amount of damages or what we intend to collect to the courts by a deadline of January. That's reflected in the 26F report. That hasn't been done. Also, there was no consent to magistrate judge jurisdiction, so we won't be moving forward with that magistrate, and we'll be taking the proper steps to remove her from the case and move forward with the constitutional judge, Article 3, I believe it is, Judge Algernon Marbley. So
they back there. they back there.
They stewing.
They back there stewing.
Justice got to be had, and unfortunately, yes, this is a messy situation. Yes,
did they give a reason for staying the case the second time?
No, they didn't give a reason for staying discovery.
It's not staying the case.
Yeah, discovery, extending the stay of discovery. So now we talking about 4 months of staying of discovery.
They say, they ain't going to China. So busy thinking that we about to go over just 3 months ago. Busy concentrating on going to China, trying to get somebody to go to China. Now they seeing there ain't nobody go to China, so they say, they ain't go to China. Extend the stay on a discovery. These people way smart.
Ain't nobody going nowhere until this justice is fully served. Ain't nobody going nowhere. This ain't nothing fresh and old and over with. These people gonna be brought to justice. Every last letter in that word, to the J, to the U, to the S, T, I, to the C-E. We is not playing with these people. So thank you guys for your time. Again, all constitutional rights invoked now waived for this video. If you have any comments, leave them down at the bottom of the section of the video, and we'll be obliged to address those comments. In the meantime, in between time,
peace out. Thanks for viewing, and see you in the next video.
Sayonara. Au revoir.
Mi binamet.